All right, we're gonna get started. So, hi everyone. Thanks for joining us. Welcome to the Global Advertising Lawyers Alliance webinar on green marketing claims. I'm Jeff Greenbaum. I'm the chairman of Gala, and I'm also the managing partner of Frankfurt Kurnit Klein and Sells in the United States. This is actually my first day back in the office. So, having done a lot of these webinars from my bedroom, my living room, my dining room for the last 2 years, it is very, very strange to be back and doing it here from the office. So it is, anyway, great to see all of you and glad that you are joining us. For those of you who don't know, Gala is a network of lawyers covering more than 90 countries around the world who specialize in advertising law. Gala does lots of programs like these on a lot of different topics and also publishes a lot of great information to help marketers and advertising agencies and others do their best to comply with all the myriad of advertising laws around the world. For more information about Gala, you should definitely check out our website at galalaw.com. You can sign up for our blog. You can check out our blog. You can sign up for updates about programs like this. Also, one of the many resources that we have is we publish these incredible books on advertising law issues. We've got a 2-volume set on advertising law. We've got a set on privacy laws affecting marketing. We've got ambush marketing and many others. So if you're interested in books like that, they're available on the website as well. You should check it out. So today's program as you know, on green marketing. And we've got a great panel of speakers from the UK, Denmark, Chile, India, Canada, and New Zealand. And I'm just going to ask each one of them to introduce themselves as they speak, but you can see them there on the screen. You know, in the United States, we're in a little bit of a crossroads about environmental marketing issues. Environmental issues have become more important to people than ever before. The current presidential administration has made it absolutely clear that addressing environmental issues is a top priority. The problem is that the primary source of guidance that we have right now, which is the FTC's green guides, haven't been updated for more than a decade. And although that the FTC has announced that it's planning to update the guides, we don't have any more information about that. At the same time, individual states in the United States are starting to pass their own laws about green marketing issues. So, at a time when companies are looking to make kind of big changes to the way they operate, and as they're trying to create products that have more environmental benefits and less negative impact on the environment, they're a little bit navigating in the dark. They're relying on, decade-old guidance, also not really even knowing whether that guidance is going to reflect the current view of the current administration. And they're also trying to navigate a patchwork of state laws that are changing and that are saying some things that are inconsistent with what the federal government has said a long time ago. So not only that, but the guidance and the laws that are in force in the United States right now don't even really specifically address a lot of the types of issues that marketers are most concerned about. Companies today are making lots of broad, forward-looking commitments about what they're going to do as a company. What kind of substantiation do you need for that? There's no real guidance on that. What about rules about talking about sustainability? What are the rules about that? Can you promote specific environmental benefits of a product if product and the company overall creates a lot of negative impact on the environment? Or, does the FTC still believe that promoting the general environmental benefit of a product, that a product is green or environmentally friendly, does the FTC still believe that those kinds of claims are really misleading? So look, we don't know what the FTC thinks about these issues. We don't know where it's going in the US, but what we do know is that a lot of countries around the world are thinking about these issues and are making a lot of progress thinking about these issues. And one way to maybe figure out, what's going to happen in the US market is to hear what's going on around the world and to sort of hear about some of the decisions and changes and guidance that they've been giving to help us sort of maybe use that as a little bit of a crystal ball to understand what's going on in the US. So the goal of this webinar really is twofold. One, we're going to give you a sense of, from I think 6 different jurisdictions, about sort of what are some green marketing developments around the world to help you better think through navigating green marketing compliance around the world. But also, hopefully, this will give us a little bit of insight into potentially what's coming down in the US in the coming year or two as well. So with that brief introduction, I want to kick things off, and Brinsley is going to start and give us the update from the UK.
Thank you very much, Jeff. So I should just say, my name is Brinsley Dresden. I'm the Head of Advertising and Marketing Law at Silkin in London. We also have offices throughout the UK and in the Republic of Ireland and in Hong Kong. But next slide, please, Stacey. A lot has been happening in the UK in this area in the last year. And just to pick up on what Jeff was saying, it's quite interesting. An awful lot of advertising regulation in the UK, I would say, follows on from regulations in the United States. So often, for example, in the whole area of influencers and social media regulation, we've often looked to see what the FTC has done in the United States, and then we've tended to adopt similar principles and practices as those which have been kind of pioneered by the FTC. But in this area, perhaps, we are more in the forefront. And one of the most significant developments was that the CMA, which is the Competition and Markets Authority, published their Green Claims Code last autumn. The CMA is the equivalent, the UK equivalent of the FTC. It's the statutory regulator. And they're looking for compliance with the CPRs, which is the Consumer Protection Regulations 2008. So that's the underlying consumer law framework, the main piece of legislation which implemented the Unfair Commercial Practices Directive from EU law during those happy days of yore when we were members of the European Union, before we decided to commit an act of unbelievable self-harm by leaving the EU. Not that I'm bitter. And so the CMA have issued a full review, or they're undertaking now a full review. They've issued their code. They're undertaking a full review, basically to see whether basic notions of consumer protection law are being broken by green claims which cannot be substantiated or which are otherwise misleading. Usually it's down to substantiation. The other important thing is that, as we'll see in a moment, our principal advertising regulator, the Advertising Standards Authority, which is a self-regulatory organisation, their remit does not include packaging. And many problematic green claims appear on packaging. So the ASA just can't tackle those. They don't have the remit to do so. They don't have the right to do so. So it was important for the CMA to get involved, number one, to kind of up the ante and bring in criminal law concepts to this area of advertising regulation. And number two, to fill this very important gap in relation to packaging claims as opposed to advertising claims. And one of the first areas they're going to look at is fashion, where there's a feeling that there's a lot of misleading claims. Next slide, please, Stace. The code itself that the CMA introduced actually didn't say very much that's new. There's a lot of detailed guidance which was issued with it. There's like a 50-page guidance document, but the code itself is pretty basic, and I won't read them out, but the principles are set out on this slide, and they very much reflect the pre-existing principles that come from what's called the CAP code, which is the Code of Advertising Practice that's been administered by the Advertising Standards Authority, and that's had a whole chapter on environmental claims for decades. And there are numerous decisions that the ASA have made about environmental and green claims and greenwashing going back 20 more years. It's an issue that sort of ebbs and flows a bit in terms of how high up the ASA's agenda it is. It was really important about 10 years ago. Then it seemed to kind of slip down the agenda a bit as other things took over and became a bigger priority, like social media advertising. Now it's gone right back to the top of the ASA's agenda again. Next slide, please, Stacey. And so around the same time that the CMA issued their Green Claims Code, the ASA also issued a statement saying that they were going to issue some more guidance, which they have now done, and also conducting some inquiries into priority areas, particularly around cars, which is obviously now everyone's advertising cars, electric cars, hybrid cars. Nobody understands the difference between the different types of hybrid cars, for example. So that's been a priority for the ASA. And also they're trying to do some research into what consumers understand by claims like carbon neutral and net zero. So I want to just look at a few case studies. The first of these is a website ad that Hyundai had on their car, on their website for the Nexo, which is a hydrogen car. So it really is a very, very green type of car. Basically, it combines oxygen and water with a fuel cell, and it makes the car go. I don't know the details of the mechanics of it, but it seems very, very clever. One of the features of the car, and if we could go to, and so just before we move on, actually, just go back, Stacey, sorry. Just to be clear, what you have there then is the car, which is apparently stationary. The tailpipe is linked to this plastic bubble. The woman is on the running machine, and apparently she's breathing the gases which are coming out of the exhaust pipe of the car. And the claim, a car so beautifully clean, it purifies the air as it goes. So if you could go to the next slide, please, Stacey. One complaint about this website ad for hydrogen hydrogen-powered car, that it was misleading and couldn't be substantiated, that basically it was exaggerating how clean the car was, with particularly not so much with that visual, but more with the claim about cleaning the car, cleaning the air as it goes. Hyundai explained that the car had a filter that removed more than 97% of dust and gas from the air, and that once that had been put into the fuel cell, what was expelled was purified air that you could literally breathe. But the complainant said, this doesn't take account of the dust that comes from the brake system and from the tyres, and therefore it's not purifying the air as it goes because of this other dust. And the ASA agreed with that very strict interpretation and said that, okay, we think consumers are going to think that it has no environmental impact at all, it contributes no impurities, and therefore that this was an exaggerated claim. The ASA say this, they didn't produce any evidence that consumers understood it to have that very, very kind of precise meaning, but they upheld the complaint nonetheless. If we could look at the next one, please, Stace. So this was an ad for a milk, and there's a nice thing, I think my friend Johan is also going to be looking at a similar kind of product from the Danish perspective, but this is one from the UK in September. So it's an almond milk, basically, range of products, or a plant-based substitute for milks, with three claims, really. Your recipe to a healthier planet, and then deliciously plant-based in the leaf that you can't really see terribly well. Good for the planet, good for you. So good for the planet. Next slide, please, Stacey. And again, only one complaint. It only takes one valid complaint for the ASA to investigate. And the complaint was whether the claim good for the planet was misleading and could be substantiated. Alpro said, well, consumers will understand this to mean that plant-based products like Alpro have less of an environmental impact than dairy milk. Obviously, we all know what cows do and the effects that that has on the environment, and therefore this was better. The ASA said no. Good for the planet. The ASA hates these kinds of generalized type claims. Good for the planet. It could mean any number of things, including that there's a net positive impact on the environment. So they upheld the complaint. It's an interesting contrast to an earlier complaint about a similar type of product from a few months before. And if you look on my blog, you'll see I sort of do a comparison of the two decisions and to why the other one, which was substantiated on a cradle-to-grave basis, was allowed by the ASA, whereas this very general one with only limited substantiation was not allowed. And then finally, my next example, please, Stacey. This isn't the actual ad. I'm afraid I couldn't find the actual ad, but this was an ad for Lipton iced tea. And if you go to the next slide, please, Stacey. The claim was deliciously refreshing, 100% recycled, asterisk, to small print with the weasel words, bottle made from recycled plastic, excludes cap and label. And the ASA decided, well, consumers would see the headline claim, 100% recycled, and they would assume, not unreasonably, that that applied to absolutely everything, including the cap and the label. The disclaimer was quite small and could be missed by consumers, and also the disclaimer contradicted the claim. The product is not 100% recycled, it's only the bottle itself, not the label and the cap. So that complaint was upheld. So I think all of these, the key take-up from all of this, if there's any flaw in your substantiation, if there's any element of overclaim that you're making in the context of these sorts of environmental claims, the ASA is going to come down on you very, very hard and uphold the complaint. And this is now causing considerable reputational damage for brands.
All right.
I think that's my allotted time.
Great. Thanks, Brinsley. We're going to switch to Denmark. Johan? Johan, I think you need to unmute.
We are. Can you hear me?
Yep.
Yeah, I'm talking from my electric car because there was an accident and I couldn't get to my office. But I'm happy to be on this webinar. I'm the Danish representative of Gala, and I do a lot of litigation on advertising law. Denmark has always been a very prominent country for environmental issues. At least we believe so. Denmark is one of the, I think we overstepped the boundaries yesterday for our share of the environment. So the rest of the year we are taking credit from the bank. So Denmark is using a lot of natural resources. The highlights of what I'm going to talk about is that, first of all, green marketing is a high priority for the consumer ombudsman. We have a consumer ombudsman in Denmark who is basically not very well funded, but has a lot of work to do, which means that very often they have a hard time keeping up with emerging issues. And right now, when pretty much every company on the planet is making green claims or environmental claims, they have a really tough time. They've just issued new guidelines. However, the guidelines are pretty much a remake of guidelines issued about 10 years ago. So there's not much help to be obtained. Carbon neutral claims, etc., are not really covered by the new guidelines. So we're still a lot in the dark. Another thing that is interesting from Danish perspective is that NGOs and lobby organizations are taking a firmer action in these matters, and I'll come back to that. And then I'll have a few ongoing cases to talk about. Stacey? As I said, we have the consumer ombudsman who is monetizing the area of green claims as well as a lot of other claims. And we also have, which is not in the slide, the Foodstuff Administration, who is handling all issues related to labeling on packaging of foodstuffs. I will have one case involving the Foodstuff Administration. The consumer ombudsman can give non-binding opinions. It happens quite rarely, but he or she has the right to issue injunctions and fines if breach of the law is particularly severe. Stacey? The quick guide on green marketing claims, as I mentioned before, is a shorter version of the 2014 guide. It targets readers, companies making green marketing claims. And one of the basic principles is that green marketing claims must be considered from a full life cycle assessment. And it requires, it's focusing very much on documentation. The consumer ombudsman is of the opinion that if climate advantage claims are made, they must not be just of marginal importance. Furthermore, they must not be obtained through processes which themselves can harm the environment. And they may not be claimed if the advantage is insignificant compared to the overall impact of the product. And finally, they may not be a regular feature of the product type in question. So the more a company is explaining their green marketing claims, the easier it will be for them to follow the law. And furthermore, very broad claims are obviously very often misleading or false. The EU Commission just issued a report a couple of months ago, and it turned out that the various consumer organizations in the EU countries had come to the conclusion that about 42% of all green claims made were either false, exaggerated, or deceptive. So there are obviously a lot of claims out there that need to be reviewed, and the Consumer Ombudsman has a very tough situation trying to keep up with all these claims. Stacey? As I mentioned, NGOs are now entering the scene as well, because as the Consumer Ombudsman has limited resources. We are now seeing private actors who are themselves either flagging misleading false green claims on the internet, leading to shitstorms and the like. And we have also seen one case of an NGO actually suing a company for misleading advertising, and I will show you that in a minute. Organizations are also lobbying for plant-based foods. We have in Denmark a very high activity on plant-based foods, and obviously companies promoting that kind of products are very eager for other companies to follow the law on green marketing. This is one of the, was that the next one? Yes. Going back, this one, yes. The Arla case, it's about the biggest dairy company in Denmark. They were marketing a milk product with the claim that it was CO2 neutral. And then below the CO2 neutral, as you can see on the package, it was mentioned in smaller text, compensated with climate credits. One of the NGOs complained to the Foodstuff Administration and indicated that it was misleading because people would expect that it was CO2 neutral from production, when it was in fact compensated with climate credits. So the NGO believed it would be more fair and correct to actually mention instead that it was climate compensated, or a similar claim which did not refer to the product as such being CO2 neutral. The Foodstuff Administration, who is they are not the most reliable source of decisions, but they actually ruled in favor of Arla, saying that although CO2 neutral was quite prominently displayed on the packaging, the fact that compensated with climate credits just underneath was enough for the consumer not to be misled when they saw the package. It should be mentioned that Arla removed the package from the stores when the case emerged. So it shows that companies are really concerned when they are challenged with green marketing, false green marketing claims. The case has now been appealed to the Environmental and Foodstuff Board, which is a board that decides appeals from the Foodstuff Administration, and it is still pending. So it will be interesting to see how this issue is actually dealt with, because there are a lot of companies who are making claims of CO2 neutrality based on various compensation schemes, and thus it will set the new standard for use of such claims. Next slide. This case is the case I mentioned before about an NGO, the Climate Movement, who sued the largest meat production company, butchery in Denmark, Danish Crown. Danish Crown was making a claim about their pigs or their meat, that it was climate controlled pig. And they also made the claim our pigs are more climate friendly than you would think. It's a very interesting case as well, because it's not direct claims as such, but it sort of hints at pig meat being more environmental friendly. So it's definitely a greenwashing claim. That also was removed from shops. Actually, most of the supermarkets banned the label when the case hit the news, and the case is still pending. So we will have courts quite soon to rule on whether this is legal or not. Stacey, the last one. This is a very new case that came up. Mercedes-Benz has apparently made a change in their manufacturing process in Germany, so that from 2022, all their factories will be powered by renewable energy. And then they have made this very beautifully looking windmill, closely resembling the Mercedes-Benz Star. And that has also been brought before the Consumer Ombudsman, because an NGO believes that this is definitely greenwashing. The big issue here is that, measured in carbon footprint, the move from coal or fossil fuel powered factories to renewable energy factories only adds about 1% to or removes 1% of the carbon footprint from the production of a car. So the advantage to the environment is sort of negligible, and therefore it is believed that this this advertisement is in breach of the law.
Great.
Okay.
Thanks, Johan. That's terrific. We're going to now head across the Atlantic and hear from Reema in Canada.
Thanks, Jeff. It's a pleasure to be here. So my name is Reema Mahbubani, and I'm a regulatory lawyer at Miller Thomson. Before jumping in, I would like to start with a quick and short disclaimer that anything said here are my own views and not reflective of the views of Miller Thomson or any of our clients. Next slide, please. Today, we will focus on two main questions. One, where are we now? And two, where are we going? I will begin by providing a brief overview of the regulatory landscape in Canada, and then highlight recent matters and areas of focus, including ongoing investigations and enforcement activity. This will lead us to consider contextual factors to provide some insight into what we can expect in the near future. Next slide, please. So in Canada, environmental claims are primarily regulated by the Competition Bureau, which is a federal government agency. The enforcement of environmental claims is not a new phenomenon for the Bureau. In fact, it continues to be an area of active enforcement. Environmental claims are typically assessed by the Bureau under the general deceptive marketing provisions of the Competition Act, which are quite broad in nature, as they prohibit making any unsubstantiated or materially false or misleading claims. As previously flagged by my colleagues on the panel, many environmental groups are actively monitoring this space. This is important because under the Competition Act, the Commissioner of Competition has a statutory obligation to investigate 6 resident complaints, which are complaints that are brought collectively by 6 Canadian residents. Using this process is a common way for environmental groups to bring consumer protection issues to the Bureau's attention. And time again, we see this as a common trend here in Canada and around the world. In addition to regulation by the Bureau, environmental claims can also fall within the purview of provincial consumer protection statutes, as these are often cited in consumer class actions and are also subject to regulatory enforcement. In terms of private litigation, enforcement action by the Bureau typically leads to consumer class actions. Lastly, environmental claims can also be considered by Ad Standards, which is a self-regulatory body that provides a platform for consumer complaints and competitor disputes. Next slide, please. In terms of recent matters and areas of focus, claims regarding recyclability, sustainability, and flushability have been at the forefront. As I touched upon earlier, enforcement of environmental marketing claims is not a new phenomenon for the Bureau. In the past, it has enforced provisions of the Competition Act against environmental claims relating to diesel engines, water heaters, among various others. More recently, the Bureau entered into a consent agreement with Keurig Canada to resolve claims surrounding the recyclability of its coffee pods. The Bureau's investigation was initiated by the 6th resident complaint process that was highlighted earlier. In particular, the Bureau found that with the exception of 2 provinces, British Columbia and Quebec, the pods were not widely accepted by municipal recycling programs across the country. And as such, the general recyclability claim was found to be materially false or misleading. Further, because local recycling programs require additional steps to recycle the pods, the dump and toss method of recycling was also found to be false or misleading, because consumers had to go through extra steps in order for the pod to be recycled. So as part of the consent agreement, Keurig Canada agreed to pay a $3 million penalty, change its recyclability claims on its packaging, and also enhance its corporate compliance program. What I found really interesting about this consent agreement is that the discussion found in the Bureau's 2008 environmental guide, which I'll talk about shortly, and which was archived last year, there's a lot of discussion from that guide that was built into the consent agreement. I thought that was interesting because, you know, the guide is quite dated, and in fact, it was archived because it didn't reflect the current practices or policies of the Bureau. So that was a quite interesting read. In respect to sustainability claims, the Bureau is investigating claims relating to sustainable forestry and other climate-related claims, 2 of which were brought to the Bureau's attention in 2021 through the 6th resident complaint process. In respect to the climate-related claims, the issue here is that these claims are not easy claims to deal with, because a lot of the representations that are being complained about have to do with future-oriented goals that many companies have. With that, what that will be down the road in a very uncertain world, I think time will tell, but this is a very hot and developing area. In respect to flushability claims, the Bureau's investigation regarding claims made by manufacturers of flushable or single-use wipes is ongoing. And the investigation was sparked after receiving a 6th resident complaint in 2019. Next slide, please. Recently, the Bureau has shown an expanded interest in consumer protection issues, including those relating to environmental marketing claims. Through the Bureau's 2020-2021 presidency of ISPEN, the International Consumer Protection and Enforcement Network, the Bureau worked alongside ISPEN member nations from over 65 countries to consider new ways to approach deceptive marketing and advertising matters. It is important to note that misleading environmental claims were a key area of focus. In particular, member nations coordinated international sweeps. These are dedicated periods of international research by member agencies to prepare a list of websites for possible enforcement action later on. In respect to the international sweep focused on misleading environmental claims, ISPEN members analyzed about 500 websites promoting products and services across a range of sectors, including clothes, cosmetics, food, and many more. In this sweep, member nations found that 40% of these websites, approximately 200, appeared to be using tactics that could be false or misleading. The Bureau's response following the release of the report was to issue a bulletin warning Canadians to be on the lookout for fraudulent environmental claims and urging them to report such claims to the Bureau. This indicates that the Bureau wanted to keep the momentum going in respect to the intelligence gathering efforts relating to environmental claims. Moving on to guidance update. As briefly highlighted earlier, in 2021, the Bureau's main environmental claims guide was archived. At the same time, the Bureau released online guidance, which is a somewhat watered down version of the guide, but the online guidance is not meant to replace the guide by any means. From what I understand, the Bureau is exploring options in regards to the development of new guidance on the use of environmental claims, including international benchmarking and research. The release date of the new guide is not known at this time, but as previously mentioned, it is interesting to note the parallel discussion between the archive guide and the recent Keurig consent agreement. The Bureau is also in the process of amending the Textile Labeling Act, and amendments to the Competition Act are also in the works. The Bureau has also issued guidance relating to how fabrics derived from bamboo should be properly described. In terms of global coordination, the Bureau entered into an arrangement with global competition law authorities in an effort to improve their collective ability to cooperate more effectively on investigations. Now, while this new framework complements the Bureau's existing cooperation agreements within these jurisdictions, it's important to note that in addition to sharing experiences and working on joint projects, this initiative also allows for focused investigative assistance, which includes sharing confidential information and cross-border evidence gathering. Lastly, the Bureau's funding for the next 5 years has been increased by approximately $96 million. A significant portion will be directed to increased active enforcement in the digital space, which includes new digital tools. In fact, the Bureau has announced the creation of a new branch that will be the center of its digital enforcement and intelligence capabilities and will drive the actions of the Deceptive Marketing Practices Directorate, among other branches at the Bureau. Next slide, please. So it's safe to say that the rise of environmental representations to the public, including things like net zero commitments, have led to a significant increase in consumer protection investigations and enforcement around the world and even in Canada. It is likely that we will hopefully receive an updated environmental guide which reflects current environmental issues in the next little while. This will be very helpful because when you're making net zero commitments and climate change related commitments that involve carbon offsets, you're often making projections that are well-intentioned, but there may be circumstances that may prove challenging to do that. And so what kind of scrutiny should be expected? What kind of scientific substantiation will be needed? These are all questions that need to be addressed. I think moving forward, especially when you look at the kind of complaints that are being made by environmental groups, the updated guidance should clarify what the line is between this environmental commitment from a well-intentioned company and the regulatory scrutiny from the Bureau. We're also likely to see continued coordination among global partner agencies. We're seeing this in other areas relating to competition law as well. Lastly, we will likely see increased enforcement activity resulting from ongoing investigations and possibly resulting from the ISPEN sweep. So to conclude, there will likely be significant movement and change in Canada in the next little while relating to environmental marketing matters. So stay tuned.
All right, thanks, Reema. Now we're going to switch to Constanza in Chile. Constanza?
Thank you, Jeff. Hi. Hello, everyone. My name is Constanza Pasarin from Chile, and I am an associate lawyer at Albagli Zaliasnik. I work on the IP Tech and Data Group. Next slide, please, Stacy. Today, I would like to tell you a little bit more about the environmental regulation in my country and also talk to you about green advertising and greenwashing. At the end of the presentation, I will share some cases that have occurred in practice. First of all, in terms of regulation, I would like to share that Chile's current constitution of the Republic recognizes the right to live in a pollution-free environment. In addition, the state has the obligation to protect and preserve nature. Although the introduction of this right some years ago was a great step forward, today we are in a historical process of reforming our constitution. Currently, different initiatives and reforms are being discussed in the Constitutional Convention. In fact, one of the most important debates has been the environmental, because they are looking to a complete reform that includes more guarantees for our environment. In addition, different native peoples are being consulted about their opinion on these matters and have been invited to actively participate in the debate and the construction of this new normative. Secondly, our environmental legal system is based mostly on the law number 19300 that regulates the general basis of environmental care. However, one of the most innovative initiatives of recent times was the promulgation of the law that prohibits the use of plastic bags around all the country, and also the regulation that establishes the promotion of recycling. All of them are intended to provide guidelines on this matter so that both consumers and suppliers can actively participate in the process of recycling or in the reduction of the use of plastic. Next slide, please, Stacy. Thank you. In this part of the presentation, I would like to talk about green advertising and greenwashing. First of all, green advertising is a type of publicity that have certain characteristics that allow it to be identified. For example, is it a kind of advertising that directly or indirectly refers to a relationship between the product and the environment, or a service and the environment? It has also been understood as a type of marketing which promotes an environmentally responsible lifestyle, or that which presents a responsible corporate image. In general terms, green advertising can be understood as publicity that makes an environmental claim, or that which covers an environmental aspect of certain product or service. We know that this type of advertising has grown in the recent years. However, the main problem that the authorities in Chile see in this kind of matters is the lack of clear and timely information that is delivered to consumers. Next slide, please. Thank you. On the other hand, we have the concept of greenwashing. This is a type of misleading advertising that attributes certain qualities to a service or product, which are positive to the environment. For example, when in reality, the company have not implemented environmentally responsible practice. Greenwashing can be carried out in different ways. One of the most commonly used ways of promoting this kind of marketing is, for example, the use of certifications that are not valid, or the implementation of green advertising campaign, or also the use of packaging that is environmentally friendly. The main problem of this type of advertising is the lack of evidence that is in what is communicated to the consumers, and that is beneficial for our environment, along with the use of a complex and misleading language. Next slide, please. Here in Chile, there is no specific regulation in connection with greenwashing. However, the Consumer Protection Law establishes certain rules to protect the right of consumers. One of the most important in general is the right to receive truthful and timely information about the product or service offered. In addition, the regulation establishes that any information appearing on labels must be verified. In practice, the Chilean Code of Advertising Ethics, mostly known as CONAR, has attempted to regulate this type of advertising in more detail. It is important to know that this code of conduct established self-regulation. However, in practice, it is respected by companies and advertising agencies. Specifically, Article 27 deals with environmental advertising, from which it follows, among other things, that advertising may not exaggerate environmental attributes or falsely suggest that a product or a service has officially approval, for example, or a third-party certification. In general terms, this article sets out the standards and the limitations to which advertisers must adhere when making advertising of an environmental character. Next slide, thank you. Now, I would like to refer briefly to some cases that have occurred here in Chile in the practice, where this type of situation is evident. In the first place, we come across an advertising campaign developed by Jeep, which appeals to consumer public to drive their vehicles in the dams, which have been declared a nature sanctuary. This type of advertising obviously incites other people to engage in a prohibitive behavior that is detrimental to our environment. The same happened in a case of a Coca-Cola advertising in which a group of people lit a bonfire on the beach. The CONAR in that case declared that this type of conduct will violate advertising ethics. Next slide, please. Thank you. Another example of greenwashing is this advertising in which a retail company promotes clothing that supposedly had characteristics and components that made it environmentally sustainable, when none of these facts in the practice could be proven. Finally, I would like to highlight the opportunity we have today in Chile to reform our regulation from the constitutional process we are living today in order to provide more protection and regulation on issues that are so important and relevant to everyone now in these days, such as environmental care. Thank you very much.
Thanks so much, Constanza. All right, back across the ocean, we're going to now hear from India. Kanu?
Jeff. Hello, everyone. I'm Kanu Priya from India. I'm a partner with the firm Can & Krishme. Today, I'm going to briefly cover the practices and regulations concerning green marketing in India. According to the World Air Quality Report released by IQ Air, world's two most polluted cities are in India. Delhi is the world's most polluted capital for the fourth consecutive year. Air pollution levels here in 2021 were almost 20 times above the WHO's safety limits. So pollution is no longer the concern only of political leaders or environmental activists. Rather, the general public is paying the price of degrading environment. This has shifted the perspective of Indian consumers. They now want the brands they associate with to mirror their concern for environment and sustainable growth. Brands are aligning themselves with consumers' expectations in order to build their progressive and pragmatic image. They are focusing on green marketing. From Tata's green batteries to Reva's electric car and MRF's eco-friendly tire, everyone is claiming to be green. Be it multinational companies or small businesses, everyone's jumping into green wagon. Sadly, not all efforts are genuine. Markets are flooded with brands who are falsely portraying their products as green or eco-friendly. They do so either by green packaging or using environmental imageries or by misleading claims without substantiation or by making irrelevant claims. Even some of the big businesses claiming to follow eco-friendly practices are in reality involved in greenwashing. They definitely do not practice what they preach. One of the companies whose action has led to considerable environmental damage in India is Unilever. Next slide, please. Unilever is a self-proclaimed sustainable leader with a zero deforestation policy. It has to be acknowledged that Unilever is indeed doing much more for the environment than most other companies. Yet, the Indian subsidiary of Unilever, Hindustan Unilever Limited, illegally disposed tons of mercury waste at a local scrapyard in the South Indian hill station of Kodaikanal. The Kodaikanal factory of Hindustan Unilever Limited was shut down by state environmental regulators. In 2018, HUL received permission from the state regulator to commence full-scale soil remediation at its former factory site in Kodaikanal. But there were some activists who approached the National Green Tribunal and they contested the soil remediation standard. They said that the standard is not enough, but this standard was later reaffirmed by National Green Tribunal and subsequently by the Supreme Court of India in 2019. In 2020, to ensure soil remediation, HUL had to cut more than 4 acres of dense canopied fully grown trees amounting to over 300. So it's not a stretch to say that actions of HUL has led to considerable environmental damage in Kodaikanal. And this is actually from a company who is actually concerned with the impact of their actions on environment. Next slide, please. Now, coming on to the regulation. There are no specific laws or regulations to curb false or exaggerated green claims in India. Greenwashing claims can be covered under Consumer Protection Act of 2019 and Advertising Standards Council of India's Code for Self-Regulation of Advertising Content. Under Consumer Protection Act, greenwashing claims or false portrayal of products as eco-friendly would be considered to be misleading advertisement. Misleading ad has been defined in the Act as any ad which falsely describes a product or services or gives a false guarantee or is likely to mislead the consumers as to the nature, substance, quantity, and quality of product or service, or which conveys an express or implied representation which would constitute an unfair trade practice or which deliberately conceals important information. The Act deems such misleading ads as an unfair trade practice. In fact, there is a Central Consumer Protection Authority which regulates such false or misleading advertisements and which imposes penalties on manufacturers, endorsers, and publishers of misleading ads. This Act of 2019 has, for the very first time, extended the liability of misleading ads on endorsers in addition to manufacturers. But endorsers would only be liable if they do not exercise due diligence. So basically, now endorsers are also liable, and upon being found guilty, the endorsers may be prohibited from making any endorsement of any product or service for a period which may extend to 1 year, and for every subsequent contravention for a period which may extend to 3 years. Greenwashing claims can also be covered under the Advertising Standard Council of India's Code for Self-Regulation of Advertising Content. The false or misleading environmental claims which are not supported by evidence and which are contrary to the fundamental principles of ASCII are not allowed. As per the code, the ads must be truthful and all claims relating to matters of objectively ascertainable fact should be capable of substantiation. It is very important to be able to substantiate the claims. ASCII may call upon the advertisers to substantiate such claims. If advertising claims are expressly stated to be based on or supported by some kind of independent research or assessment, then the source of this has to be indicated in the advertisement. The ad should not distort any kind of facts nor mislead the consumers by means of implications or omissions. And ad should certainly not contain any statement or visual presentation which directly or by implication or by omission or by ambiguity or by exaggeration are likely to mislead the consumer. In fact, the code also prohibits the indiscriminate use of advertising for the promotion of products which are regarded as hazardous to society or to individuals or which are of a type which is unacceptable to society at large. The ad should observe fairness and respect the consumer's need to be informed of relevant details, and they should certainly not abuse the trust of consumers or exploit their lack of experience or knowledge. Next slide, please. In order to increase consumer awareness in respect of environment-friendly products, Government of India has launched an eco-mark scheme. This is for the labeling of environment-friendly products. So the main aim of the scheme is to encourage the consumers to purchase those products which have less harmful impact on environment. This scheme is administered by the Bureau of Indian Standards, and it covers various product categories like soaps, detergents, paints, food items, lubricating oils, electrical and electronic goods, food additives, amongst others. And this scheme provides certification and labeling for such products, household or consumer products, which meet certain environmental criteria along with their prescribed quality requirements. Next slide, please. Government of India has also issued guidelines on responsible business conduct, which requires the businesses to assess environment impacts of their products and operations, and to promote and advertise their product in such a way that the ads do not mislead or confuse the consumers or are not against the principle of these guidelines. Next slide, please. Even though the greenwashing claims are covered under Consumer Protection Act of 2019 and ASCII's Code for Self-Regulation of Advertising Content, there is a clear need to have guidelines on green advertising to curb the practice of greenwashing. Because as of now, the only legislation is Consumer Protection Act, and it does not directly refer to green marketing or green advertising, although they are protected under misleading ads, but there's a requirement for a clear guideline, maybe from Advertising Standard Council of India, on such environmental claims, so that this practice of greenwashing can be done away with. That concludes my presentation. Thank you.
Great, thanks, Kanu. Okay, and finally, across the ocean again, and we're going to talk to Julika from New Zealand. Julika, you're up.
Hi everyone, I'm Julika Wahlmann-Smith from Hesketh Henry. I'm a senior associate in our commercial team, and within that focus on advertising law and intellectual property. So today I'm just going to talk about regulation of environmental claims in New Zealand, and then touch on some themes that we've been seeing in recent cases, and talk about something that we see throughout all environmental claims, which is substantiation. Environmental claims in New Zealand are fundamentally regulated through our Fair Trading Act. It has a range of different sections which prohibit misleading and deceptive conduct in trade, and have more specific prohibitions, including in relation to manufacturing processes, suitability for purpose, and the like, as you'll see set out on your slide there. The Commerce Commission is the regulator that is primarily responsible for enforcing the Fair Trading Act. Alongside our Fair Trading Act, we also have our Advertising Standards Code, which is the code of our Advertising Standards Authority, which covers environmental claims, including with a specific rule that environmental claims must be accurate and able to be substantiated by evidence that reflects scientific and technological developments. Recycling claims are particularly popular. Of course, consumers are trying to use the products that are best for the environment, and one easy way of doing that is a product that is recyclable. So they have, of course, become very popular with advertisers, and then drawn the attention of the Commerce Commission as well. One such recent case was regarding a disposable coffee cup. So here in New Zealand, there had been a move away from disposable coffee cups to the bring your own cup, but with COVID, that's changed to go back to the single-use disposable coffee cups. And with that, of course, consumers are looking for which option are most environmentally friendly. So this one looks great because it's actually said to be recyclable. Most coffee cups in New Zealand are not recyclable, but this one was different in that it didn't have the plastic layer that many others do, and accordingly it was technically recyclable. The entity involved had even got test results from a testing organisation in Germany to show that the cardboard was in fact recyclable. The difficulty was that in New Zealand, coffee cups are not accepted into curbside recycling. That is because since most coffee cups are not recyclable, the processes can't differentiate, and accordingly you can't just put it in your curbside bin. The Commerce Commission then took the view that consumers would consider the term recyclable to mean that it is recyclable in the curbside recycling and easily recyclable, and since that was not the case, that this would be considered misleading. In this instance, it was just a warning letter, and all the advertising had to be removed, which the advertiser complied with. But it is a good example to show that when you're launching a product, you need to look at the local market and to make sure the claim is actually appropriate for where the product is being used. The next theme we're seeing is around zero or low carbon emission claims. So in New Zealand, this is a very big topic. We have, in fact, even made an amendment to our climate change response bill to have a target of net zero greenhouse gases, excluding methane and agricultural gases, by 2050. And so, of course, we've seen many advertisers jump on board and make some claims that people think are helping move us to reach that target. One such advertisement was a voiceover in a gas advertisement, which said New Zealand's heading toward zero carbon, so we're ensuring our gas is going zero carbon too. You know what that means for you? Absolutely nothing. You can continue what you love to do and help change the world without changing too much of yours. Find out more at gaseschanging.co.nz. There were actually a number of complaints that were made against this ad, and including one which had raised several issues, including that made unsubstantiated claims and was misleading. The ASA took the view that it was making an environmental claim which needed to be substantiated, and which it did not have sufficient evidence to substantiate the actual claim, and that it was also misleading. When you looked at First Gas Group's website, it did say that it was working towards using hydrogen gas. In fact, that it might get to 100% use of that by 2050. So definitely not as imminently as suggested by the advertisement. Further, if that sort of gas or a mix of other biogases was used, consumers may need to, in fact, update their appliances to actually be able to use the gas. So again, the statement that you need to do nothing at all was also actually incorrect. The advertiser did suggest changing the ad to soften it by moving away from using ensuring, which is seen as quite a strong commitment, to moving to we're helping make sure, but the ASA thought that was not going to be enough and requested that the advertisement be removed. The other thing we do see a lot of is save the planet. So some advertisers simply go straight to the point and make an easy claim that consumers will read and think, okay, this is a good product to purchase when in a rush at the supermarket, for example. There are, of course, a myriad of complaints that come in with these sort of claims. Most of the time, those complaints rely on raising the principles that you see right there on the slide, including that advertisements must be truthful, balanced, and not misleading. There is, however, an exception for obvious hyperbole. And in recent cases, the ASA has taken the view that often these sort of statements are actually more of a general or aspirational nature and are okay to be used. So a recent example was Harrison's Energy Solutions, an advertisement for solar panels that said slash your power bill and save the planet. A complaint was raised about it, but the ASA thought, look, consumers' take-out was that using renewable energy and solar panels was generally more environmentally friendly than fossil fuels, and that a consumer wouldn't think that simply by doing this, they were actually going to single-handedly change, climate change, basically. And then now we'll move on to substantiation. So this runs across all types of advertisement, including green advertisements. Advertisers have to have a reasonable grounds to make the representations for the duration of the time for which they are made. So you might have great grounds at the start of your campaign, and then perhaps supply issues result in some changes in the composition of your product. You need to make sure that any claims you're making are still correct all the time in which they are being made. What constitutes reasonable grounds does depend on the nature of the representation, but examples include things like test results or other credible information. Substantiation is not required for a representation that a reasonable person would not expect to be substantiated. So that was just a really quick run through of environmental claims in New Zealand. I hope that's been of some assistance. Thank you.